Welcome. I'm Vickie Patton, and I serve as Environmental Defense Fund's General Counsel. Thank you all so much for joining us today for our EDF Live update on one of the most important legal battles over clean air, healthier lives, and a safer climate. Over the past 3.5 years, the Trump administration has relentlessly sought to tear down important public health and environmental safeguards, over 100 protections. Those efforts have continued as our nation has faced a tragic health pandemic that has taken over 150,000 lives in the US and many more globally. The Trump administration has continued to relentlessly roll back these protections and safeguards. We had a recent event to talk about, indeed, how those efforts have even intensified during this tragic health crisis. The Trump administration's rollbacks have continued while a nation has witnessed with our very eyes the horror of racism in America, the death, the murder of George Floyd. And as we have, as a country, have raised our voices in a clarion call to end now and forever systemic racism in America. And yet the Trump administration continues to roll back safeguards. And it's really important to think about what's at stake with these safeguards. We talk about 100 or more rollbacks, but all of these rollbacks translate into real impacts on people's lives. At stake is whether millions of Americans will have clean air to breathe, clean water to drink. And indeed, many of these rollbacks will be afflicted on the communities, on the people, on the families who have borne the heavy, heavy burden of pollution for far too long. Importantly, the Trump administration has cut corners, and it has a disdain for the facts and for the rule of law. And with that comes legal vulnerability. And with that comes accountability. And that accountability has come through the leadership of people like California Attorney General Xavier, Becerra, other state attorney generals, Environmental Defense Fund, numerous other environmental groups and allies, as we have pushed back to enforce the rule of law and to protect human health and the environment in the face of this very serious and unprecedented threat. Overwhelmingly, the courts have rebuked the Trump administration. 95% of its efforts to roll back environmental safeguards have been turned back in the court of law. EDF's top priority, public health and climate and clean air safeguards, are still intact or are actively under litigation. At this defining moment in American life, where the stakes are profound, we are so honored and fortunate to have with us today two of our nation's preeminent environmental legal experts, the Honorable Attorney General of California, Xavier Becerra, who's brought over 80 lawsuits against the Trump administration, served in the US Congress for 12 terms, 24 years, leads one of the preeminent legal offices in the world, someone who has had tremendous success in enforcing the rule of law and saving countless lives from very serious threats and rollbacks, who's been an unwavering beacon for justice in these dark times, and Harvard Law professor Richard Lazarus, one of the preeminent experts on the US Supreme Court in environmental law, a member of Environmental Defense Fund's Board of Trustees, a Supreme Court litigator and advocate, and author of a new book, The Rule of Five, Making Climate History at the Supreme Court. First, we'll hear from Attorney General Becerra to delve into kind of the vital litigation that he's leading and the imperative for environmental justice, followed by your questions. And then we'll turn to Professor Lazarus to delve into some of the legal questions and contexts that are so pressing in this important litigation. And we'll also really welcome your questions in response to his presentation. There's a Q&A on the side of your screen. Please use the Q&A to ask questions. We welcome them, we invite them, and we welcome our just remarkable guests. Attorney General Becerra, California has filed over 80 lawsuits against the Trump administration. What is at stake in this important litigation to protect the U.S. and the state clean car standards? And thank you again for your tremendous leadership.
Vickie, first to you, to all the folks at EDF, and can I give a shout out to Sharon Stein, who has done such tremendous work on behalf of many of the lawsuits that we have filed. I know working with you all, she has been tremendous in helping us come up with the type of information that we need to be able to move forward with success in these lawsuits. So to you and the entire team at EDF, can we just say thank you so very, very much for everything you do. I'm first going to say something to the folks that are tuning in. You are awesome. The fact that you're participating means that you care. And to me, one of the things that clearly we need to see today, and it's become very evident with the events of the recent past, that we need to care. And so thank you for being part of this. Secondly, I'm going to do something that I think is critical because I'm nothing but a country lawyer, right? And I know that most of you know more about the environment and what it takes and the elements, the law, the science, the facts. I don't need to repeat a lot of that stuff to you. You probably are aware of the various fights that we're undertaking, so I won't go too far into those, maybe during Q&A. What I'd rather do is spend a little time talking about a few things that I think are important, especially after the events that we've seen. I yesterday made an announcement that my Department of Justice is going to send investigators down to Palmdale, California, to help investigate an incident where a young man, Robert Fuller, in his 20s, was found hanging by a tree. 50 miles away, less than a week before, another African-American man was found hanging from a tree. We just got to do some stuff. And so I'm going to treat this a little bit differently. And what I'm going to tell you is, well, I'm going to tell you a story. I'm going to teach you a word. And I'm going to remind you of a truth. And somewhere in there, I'm going to talk a little bit about the 84 lawsuits, half of them in the environmental space that we've had to file against the Trump administration. That story. I lost my first legal case. I tried my best. It meant the world to me to help my clients. They were immigrants, a construction worker, a clerical worker. They had to move forward with what they got, and that was me. And they had complete faith in me. They had been ripped off of what, for them at least, was a lot of money. Well, as I said, I fell hard. I lost the case. But my clients, they were extremely understanding. They were understanding with less money in their pockets, but nonetheless, they were still full of faith. Here's what I remember they said to me. Mijito, no te preocupes. Hicimos la lucha. Es lo que cuenta. Son, don't worry. We tried. That's what counts. I was in college at the time. I was the closest thing to an attorney that my parents knew. I was their best shot. But close, as they say, doesn't win. I learned a lot from my parents. And I learned a lot from losing. When you have to start working after the 6th grade like my dad, you try anything, any kind of work you can, just to make sure you're providing for yourself and then in the future for your family. When you're new to America, like my mom was when she married my father and came to this country, you call on those you can. You're not sure who, but you can. Who do you call? It's those you trust. That's what my mom did. That was 40 years ago that I lost that case. And in those 40 years, I've learned a great deal from my parents and from losing. I learned that if I try, I have a chance. Here's the word I'm going to teach you. Ganas. Ganas. No need to look it up. I'm going to give you the definition. It's better than the Merriam-Webster dictionary definition because it's the real deal, at least in my home. In my house, ganas means guts, grit, and game wrapped together. My parents had it. In these times, we need it. Ganas, it's sort of like falling forward so that even if you fall, when you get up, you're still ahead of where you were before you fell. Think about it. Think about it. If you're leaning forward, if you're always making the effort and you lean forward, even if you fall, you're still going to end up when you get yourself up, be ahead of where you were before. That's what I learned from my parents. That's perhaps why we've leaned forward 84 times against the Trump administration. And half of those efforts have been trying to protect our health, our environment, our planet. In California, we believe we have a right to protect our people, our resources, and our values. 84 times we've had to do that. And most of those lawsuits are moving forward. In most cases, if there's been a decision, it's been in our favor. Whether it's defending the clean car standards that we all rely on, not just California, whether it's pushing forward the clean power plan, whether it is protecting our communities from the release of methane gas, whether it's protecting the waters of the United States, whether it's making sure that we protect the Endangered Species Act, we're going to be there. And whether it's against EPA, NHTSA, Department of Interior, Department of Energy, we're there. We're there. And fortunately, so are three important allies: facts, the science, and the law. And we definitely rely on those three allies a great deal in court. And so when we proceed on a case, I can tell you my heart is in it because I've had my share of falls. I've had my share of disappointment. I don't like losing. And I tell my team when we go in, we're going to lean forward, because if we happen to fall, it won't be the end of the race. We're going to be getting back up, and we'll make sure that we're still in that fight. And so, ganas, guts, grit, and game. Now I'm going to tell you the truth. And this one, I think, sometimes escapes us, especially in these difficult times. And for too many people in our country, for too many communities, it seems to never exist. But it's there. In America, you can try. That's it. That's it. In America, you can try. Many of us who were born in this country don't understand what that really means. Of course, you can try. But that doesn't get you anything. If you just trying doesn't mean you're going to succeed, right? I tried my first lawsuit, didn't win. But talk to my parents and they will tell you, in America, you can try. A guy with a sixth grade education who had to start working to help his family tried. And somehow 4 kids got to go to college. A woman who hadn't stepped a foot on this country until she had married my father and come to this country at the age of about 18. Tried. And she made sure that our home had those 4 kids raised so they can go to college. America gives you a chance to try. And when you try, magical things happen. We need magical things in this country right now, because we cannot go back to where this president would like to take us. This is 2020, not 1920. And we have to try to remind the president and everyone else in America that we're moving forward. And so I can talk about all these lawsuits that we filed. I can talk about our success against the Trump administration defending our planet, our water, our air. But what really counts is the things you have inside and that propel you, sometimes without knowing whether you'll succeed. Believing that if you lean forward, even if you fall, you've still made some progress and you can get back up. And so at the end of the day, you just want to be able to not just say you're going to fight, but you're going to win. And that's the motto we take with us at the Department of Justice. We fight, but we win. And here's the beauty of America letting you try. By letting you try, America lets you punch above your assigned weight class. I guarantee you, there are a lot of places on this planet where you can't punch anywhere, let alone above your assigned weight class. And I'm going to stop here because what I want to convey to you is this. If you don't believe me that America is a place that lets you try, and if you don't believe me that America is a place that lets you punch above your assigned weight class, then I would be willing to give you the phone number to my mother, because she knows the next time someone tries to rip her off, she can call on an attorney general from the state of California to make sure that her rights are protected. He tried. I try. I believe you try. And that's why we can count on America to be heading into the 21st century. Thank you all for gathering. Thanks for letting this country lawyer spend a few minutes with you. Let's talk.
Thank you so much, Attorney General Becerra. Ganas. I'm going to open up with a couple of questions. One of the important actions that you have taken as Attorney General, and there are so many, is to establish a bureau that's dedicated to environmental justice. It also includes dedicated and visionary leaders like Arsenio Mataka. Can you share your thoughts about how the AG's office and each of us can do our part to accelerate and achieve environmental justice?
Vickie, the most important thing you can do is recognize that there are environmentalists in our poorest communities who've never signed up for any one organization to do the work or have issued an op-ed on behalf of the environment. Like my parents, they've been environmentalists from the beginning, not because they believed in it or saw the fruits of it. They had no choice. You couldn't go out and buy a lot of food in wrappers because you couldn't afford that. You couldn't afford to leave the lights on in a room when you weren't in it because they couldn't afford the utility bills. And so you were environmentalists by force, but you learn a lot. And so I hope that we reach out to communities because today they would like to prove that they're environmentalists, that they're overwhelmed by forces. We took on a matter in Arvin, California, center part of California where we still have a lot of oil drilling. Arvin was trying to create a buffer zone where oil rigs could not be drilled. They decided to push for the first time ever for a setback ordinance that would require that any drilling occur more than several hundred feet, I think it was 300, 400 feet from a school, from homes, 300 or 400 feet. Imagine if you had an oil rig no more than about 300 or 400 feet from your home. Well, for them, that was a big deal because that never had happened. And they got it done. They passed an ordinance. No one believed it could be done. We stepped in to help the city that wanted to move in that direction. New leadership there, new mayor. And I think we helped give them the courage to believe that they could make that happen. So they tried. And in this case, they didn't fall. I would hope that we would reach out to communities. And quite honestly, reach out to communities that may not be doing the best things. They just have to understand that there are better ways to move forward with projects than to denigrate the environment around those people who are low income or people of color. And so let's just all try to make it clear that we're going to fight to make sure every community is protected, because it's usually our minority and low income communities are the ones that are hit first and worst by environmental degradation.
Thank you so much. A few weeks ago, you led a national press conference, Attorney General Becerra, and you were joined in that national press conference announcing landmark litigation against the Trump administration's sweeping effort to eviscerate our nation's clean car standards. And by your side at that press conference was the Attorney General of Michigan, Dana Nessel, the Attorney General of Colorado, Phil Weiser. Sir, I've worked on these issues for 30 years. I've never observed a press conference like that or a coalition like that that includes 23 states all across our country, arm in arm with California, protecting and defending against the sweeping attack on the clean car standards. Can you say more about the coalition you forged and how important that is?
Vickie, you mentioned the importance of that coalition. It goes beyond those attorneys general who are crucial, but many in the auto industry. California has been able to reach agreement with several large automakers to move forward with clean car standards. Putting aside what the Trump administration is trying to do, they have stepped up to the plate and said voluntarily they'll move forward, even though this matter is now in litigation. Whether it's Honda, some of the other players, they've stepped forward and they're trying to do the right thing. And along with that, I will tell you that when you can get the Attorney General from the state of Michigan, which is home to America's auto industry, it sends a really clear message. And having Colorado, which is considered a state that cherishes its resources, you know that your coalition of AGs is going to be very diverse. But at the end of the day, what it is this is a coalition of folks who want to live and work and thrive in the 21st century. Not, as I said before, go back to the last century, 2020, not 1920. And we understand that we can't continue to just expose our planet to this environment that will denigrate not just the planet and our environment, but the health of our kids. Go to Central California, right, which I just mentioned before. One in every four of our school kids in the Central Valley has asthma. Just can't live that way. And so we're going to fight. And we've got a great coalition. And with that coalition, as I mentioned, we've got those three allies, facts, science, and the law, to stand by us.
Before we lose you, Attorney General Becerra, I have a question that I'd love to share with you and Professor Lazarus. It's from Dan. And Dan wrote, will the protecting human health angle be a more persuasive argument than the protecting the environment approach in the courts of law and in the courts of broad public opinion as you work to defend and protect the U.S. and California clean car standards?
I would answer that question, Vickie, by saying, first, they're one and the same. But to the degree that you parcel them a bit, the job of the courts is to protect people first and foremost. Certainly, if you're going to affect someone's health, you can show direct harm if you're affecting someone's health. We're learning how to prove through fact science how you hurt the environment as well. But I really do believe that they go hand in hand. There's no way that you can have a healthy life if your environment is polluted and degraded. And quite honestly, there's no way you can have a healthy environment if people are sick and ill and are not able to live a thorough, fulfilling life. And so they go hand in hand in my book.
Thank you so much, Attorney General Becerra, for leaning forward, for raising your voice and justice to protect people's lives. In the clean cars litigation alone, at stake is over 18,000 lives, hundreds of thousands of respiratory illnesses, billions of tons of climate destabilizing pollution. And we have hope and a real shot here in protecting these vital safeguards because you have leaned forward. Ganas, thank you.
Thank you, Vickie.
Professor Lazarus, would love your thoughts about this question.
Well, it's a great question, and not surprisingly, I agree completely with the Attorney General. In the world of advocacy, we call that framing. How best one should frame an argument to one's audience to convince them to endorse your position. And the two, environment and public health, are obviously very closely aligned. But it's certainly true. I think as a practical matter, I often find myself framing things in terms of public health. It often works better with a broader coalition in terms of the American people. And it can work better as well, even in courts of law, to the extent that public health issues often carry greater weight with judges than reliance on a very important environmental value. So the two are the same, but it's a question of framing, and public health is well worth emphasizing to the extent that it's applicable, and it most often is in the environmental context.
Thank you so much. We're going to pull Dan into our litigation coalition to help us out. So appreciate that. And Attorney General, we understand you may need to get called. You may need to step away at any moment. We appreciate so much you for being here, and as long as you can be with us. So thank you.
I'm going to get to sign off, Vickie. I'm glad you invited me to participate. Move forward. Ganas.
Ganas.
Amen.
Professor Lazarus, there are several major pieces of litigation that implicate the effort to protect the clean car standards. There's one really important case now being briefed where California, the numerous other states, a coalition of NGOs will file our opening briefs in a week and a half, Friday, June 25th, to protect the foundational state authority to adopt more protective standards, authority that California has had and exercised for over half a century, as well as the litigation now also actively underway to protect against the sweeping rollback of the national scale clean car standards. Can you say a little bit about what's at stake in these cases and some of the legal context and history that kind of underpins these really vital pollution limits?
Yes, Vickie, I'd be happy to. I'm going to share a PowerPoint screen with everybody for just a moment while I talk about all these issues, and then I'll unshare it so we can go back to Q&As afterwards. So basically, what I want to talk about first, I think he said, why do we care? We care a lot about these issues because the climate issue and the question of motor vehicle emissions, greenhouse gases, have tremendous ramifications for our lives and our livelihoods here in the United States and every part of the country, but also because of the nature of climate change throughout the world. It implicates both climate and the environment. And as I mentioned ago, public health as well, and then also fuel efficiency and the economy. The climate issue is the signature issue of the 21st century for environmental law. So I'm only going to talk for a few minutes, and I want to cover three topics. First, just give everyone some historical background so you can understand what's at stake in the current litigation challenging the Trump administration's efforts to roll back greenhouse gas emissions from motor vehicles. Second, provide a brief discussion of President Obama's initiatives during his time in his office, because of course that's the backdrop to which one has to look to evaluate what the Trump administration is trying to do in rolling back those initiatives, which are now being challenged by Environmental Defense Fund and others in court. So the historical background is the Federal Clean Air Act in California. And that's what was so fitting. We had the Attorney General from California talking to us. The Clean Air Act of 1970, which is our landmark law, it's actually our first major federal environmental law of the modern environmental era. It really was enacted by Congress because of California. California was, as it often is, ahead of the curve. California was regulating regulating car emissions in the 1960s. And it was because of California's regulation of car emissions that we managed to accomplish, with Senator Muskie leading the charge, a federal Clean Air Act, because the auto industry didn't want California to regulate separately, along with 49 other states. So they wanted national legislation. So Congress in 1970 passed national legislation regulating power plants, but also automobiles and automobile emissions. But the deal that was struck was that there would be a federal standard And then, the practical matter, one other state would be allowed to set its own standards, and if they were more stringent, and that was California. And then other states could piggyback on California. So you could have basically a national standard, and if California wanted a more stringent standard, and then any other state that wanted to adopt California's could. It wasn't, though, until 2009 before the federal government started to regulate greenhouse gas emissions for motor vehicles. So that was a good 39 years after the passage. And that regulation happened as a result of this decision. Massachusetts versus EPA decided in 2007, perhaps the most significant environmental law case ever decided by the U.S. Supreme Court, written by Justice John Paul Stevens, often referred to as environmental law as Brown v. Board of Education. And in this case, the court ruled that greenhouse gases were air pollutants, subject to the Clean Act, which the Bush administration had denied, and ordered the Bush administration's EPA to go back and look at whether or not it could make a determination that motor vehicle emissions of greenhouse gases endangered public health and welfare. A huge ruling, which really catalyzed much of what we've seen in terms of climate laws in the United States since 2007. A quick plug for my book. I actually just wrote a book all about the case. It's a fabulous, fun story for a popular audience, all about what really happened behind the scenes, both in the advocacy and in the United States Supreme Court, behind the curtains in the justices' chambers about that case. All right, let's go to the Obama administration's motor vehicle climate initiatives. So during the Obama administration, they had 8 years, and they ran with it. Within a few months of taking office, they started taking advantage of the Bush administration's loss in Mass versus EPA. And they promulgated a series of very demanding regulations, which restricted for the first time in this nation's history greenhouse gas emissions from new motor vehicles, which promised to double fuel efficiency and halve carbon dioxide pollution by 2025. An extraordinary step, and it was regulations like this the Obama administration did for both cars and for power plants and other source of greenhouse gases that made possible the historic Accord in Paris in December 2015, where almost 200 nations around the world joined together in commitments to restrict greenhouse gas emissions to address the problem of climate change. So what has the Trump administration done? The Trump administration done is they've targeted every single climate initiative by the Obama administration to be unraveled, repealed, and rolled back without exception. There's nothing that has prevented them from trying, not saying succeeding, but trying to accomplish this. The bad news is that included the motor vehicle emissions restriction. And the Trump administration's attack has been along two dimensions. First, they have sought and announced as of last fall that they're going to eliminate the authority of California to have tougher greenhouse gas emission limitations than the federal government. And that doesn't just affect California, because about 13 other states have endorsed California's authority to do that and is willing to endorse California's tougher standards. And so that's a very important cutback with serious threat to the ability to limit greenhouse gas emissions. That's the first thing they did. The second thing they did just this past spring is they basically repealed the Obama administration very ambitious emission limitations and replaced them with sharply decreased federal greenhouse gas and fuel efficiency standards for no motor vehicles, about 1/3 as effective in bringing down greenhouse gas emissions as the Obama administration has said. That's the bad news. The good news is we all knew they were going to do this. EPA has been preparing for this, and it is a battle since January 2017. Lawsuits have been filed in trial and appellate courts around the country. EPA has brought in experts for a long time, and they filed suits raising legal claims. And the other very good news is the prospects for prevailing in these lawsuits is very good. And that's a high standard. It's hard to beat the federal government in court. But the fact is that we have very good lawyers and very good experts at EDF, which is part of a broader coalition along with the states, other environmental groups. And the Trump administration, as Vickie suggested at the outset, they make mistakes. They do sloppy work. And they've made some mistakes here. They're actual just sort of embarrassing factual errors in the rulemaking, just math errors, missing data, missing years, missing model years, which can be, I think, fairly effectively challenged in court. And they've made a series of legal errors as well. There's a reason why they've lost 90 to 95% of their cases litigation. Not because it's easy to beat the government, but because with really good legal work and really great lawyers, they're quite vulnerable. But all this is just to underscore the critical significance of the election this November. One can do a lot through litigation. One can forestall things through litigation. But forestalling and delaying things is not the same thing as actually adopting the kinds of regulations we need, which is why litigation, while important and critical, is only a necessary step. It's not a sufficient step, which is why, again, the election this year is so important. And with that, Vickie, I'd be happy to take any and all questions.
Thank you so much, Professor Lazarus, and thank you so much to our members and supporters who have enabled us to be preparing for this legal battle. The reason EDF started preparing in January 2017 is because our members and supporters stepped up and recognized the serious threat that the Trump administration posed and enabled us to be on the strongest possible footing for this and many other really crucial legal battles. Let's turn right to questions. We have a question from Larry, and Larry asks, might the reasoning of the Shelby County decision by the U.S. Supreme Court be used to justify tearing down and overturning California's authority, in particular the preemption waiver that has enabled California to take action and adopt more protective standards?
Right. That's a pretty smart question, right? And a very sophisticated question. Let me give everyone, I don't think everyone will necessarily know what the Shelby County case is. The Shelby County case was a case decided by the U.S. Supreme Court a few years ago involving the Voting Rights Act. It's not an environmental case. And it's a case where the Supreme Court ruled that Section 4 of the Voting Rights Act was unconstitutional because the factual predicate for subjecting certain states to heightened review of their restrictions on voting was no longer applicable, that factual predicate upon which Congress had based the Voting Rights Act was 40 years old. And the Congress wanted to justify, they had to do a new factual predicate. Their facts were too dated for it. And so the court said the Voting Rights Act Section 4 is unconstitutional without a better factual predicate. So I guess the question here is whether the courts are similarly likely to second guess the factual predicate of California wanting to have stricter greenhouse gas emission standards. So that's how the two are similar. I don't think one leads inexorably to the other. One is a question of constitutional law and Voting Rights Act. The other one is a question of statutory interpretation of the Clean Air Act and whether California has exhibited extraordinary and compelling circumstances that justify a stricter standard. Certainly, to the extent that one wonders whether courts will be aggressive and active in second-guessing the decisions of Congress or states, the more aggressive they are, that shows a willingness to second-guess the other branches of government. So to that extent, Shelby could be viewed as a harbinger, but I think the two issues and legal issues are sufficiently distinct that the fact the Supreme Court ruled one way in the Shelby County case doesn't tell us the answer to what they'll do if they get a chance to review the authority of California to have stricter greenhouse gas emissions. But it's a wonderful question, especially for a law professor. So Vickie, ready for the next question?
Thank you, Professor Lazarus. Another question in the book about Massachusetts landmark Supreme Court Can you say a little bit about your thinking and perspective now and for generations to come?
Yeah, so this was a great story. Massachusetts versus EPA was this case which never should have happened. The people who brought it was sort of a ragtag group of environmentalists. This one guy all by himself in Washington, D.C. is basically decided to challenge, actually, the Clinton administration originally and the Bush administration. So I think the lesson of the case was that really good lawyering makes a difference. One person can make a difference. Here we had one person who initially brought this case against all odds, against EPA, and then a different person sort of picked up the cudgel and ran with it when everyone else wanted to give up on the case. And then they took it to the Supreme Court, where a lot of people were worried, but they could lose their heads. And then they went to the United States Supreme Court. They could have easily lost in the Supreme Court in a heartbeat. And instead, this magical justice, John Paul Stevens, I often refer to the book as the Jedi Master of law and of being a judge. He cobbled together a 5-justice majority, working really hard to get Justice Kennedy's 5th vote in that case. It took him 8 drafts to do it, and a lot of compromises. So it's a case about hope. It's a case about the importance and power of positive thinking and good lawyering, and really strategic, smart litigation done by states, including California, and environmental groups, both in the D.C. Circuit and the Supreme Court, and how you can make history. The one argument which I never like is when my students say to me that someone else is on the wrong side of history. I think that's a foolish argument, because it assumes history will go the way you want it to go. You fight for history. You can't assume history. And this book, The Rule of 5, tells you how to fight for history and the rewards of history. The other lesson that I would take from Massachusetts versus the EPA and the book, The Rule of 5, is that litigation, like doing right now, the Trump administration, is incredibly important. And it can be historic and make all the difference in the world, but it's not enough. At the end of the day, in the United States, the way we make laws in the United States, the way we achieve transformative laws, is not just through litigation. It takes more than the votes of 5 justices to actually have long-standing, persistent, deep change. It requires elections. And that's why this election coming up is so important. It's why the election in November 2016 was so devastating to those who care about so many issues, environment being one of them, but so many social justice issues. And we're going to make it to November 2020. It's been a tough 4 years, but we can't afford a repetition. If they do, we'll be back in the courts, but it's far better to win the ballot box too.
Professor Lazarus, Dick has a question that reads as follows. The states' rights argument has a very checkered and complex past in U.S. history. To what extent does that argument have new energy and validity today in endeavoring to protect states' rights to more protective health and environmental standards?
Just another great question. I mean, those of us who sort of grew up, as I did, in the 60s, thought of states' rights as anti-civil rights. That you thought of states' rights as something which sort of undermined the civil rights of individuals. But we were naturally inclined to national rights and national legislation, which overrode state law. And that was sort of often a liberal progressive agenda, was a focus on national legislation that preempted the rights of states, because people were often thinking about states doing too little rather than states doing more. The lessons for everyone, but certainly including environmentalists over the past few decades, is that you don't want to take away states' rights. You want the federal government to provide a floor of what is minimally necessary, but we need the states. We need their creativity. We need their closeness to the problem. We need their credibility they have with the communities they represent. We can't rely on the federal government by itself. You can't achieve social justice. You can't achieve environmental justice. You can't achieve environmental protection unless you have a partnership. That partnership includes allowing the states not to undermine the national standards, but to supplement them and come up with really creative solutions. That was one of the beauties of President Obama's Clean Power Plan. This plan, which was going to dramatically reduce emissions of greenhouse gas from power plants across the country. It was a plan which didn't just sort of promote a one-size-fit-all to all states, but it said, looked at the states, looked at the different circumstances, came up with what they thought states could do. Then let states figure out the best way to do it. Give them enormous flexibility depending upon their own circumstances and their own priorities to achieve what was necessary for the country and actually ultimately when it comes to climate change for the world. So states' rights, which was sort of a bad thing in the 60s, is now widely accepted as a really positive thing. And we've seen it with the global pandemic and the pandemic in the United States. The need for a guidance from the federal government, which we're missing, but how we also have to have leadership from the states. And there's no substitution for that.
Gernot asks, what does the current Supreme Court term tell us about how the High Court might rule on the clean cars litigation? There have been a couple of major rulings on the environment, a Superfund case, an important Clean Water Act decision, and then yesterday's pipeline ruling. What do you see when you review these rulings and think about the fate of the clean cars litigation?
Yeah, I think what the Supreme Court's term underscores in the last few months, looking at the County of Maui Clean Water Act case, which was actually a huge victory. The Atlantic Coast Pipeline case yesterday involving the Appalachian Trail and the authority of the Forest Service to authorize a pipeline to be underneath, a disappointing result. But all these cases have something in common, as does the historic decision by the court yesterday in the Boston v. Clayton County LGBT case under Title VII of the Civil Rights Act, and that is that text matters. These are justices who care about text. If you convince them there's no wiggle room under the text, that the Congress really has provided for the result that you're seeking, you can get their votes. They may not be your political allies. They don't have to be. They are often guided by text. So in the County of Maui Clean Water Act case, right, we won that case. Won that case big, 6-3, a huge win, involving basically whether or not the County of Maui had to regulate these discharges into the Pacific Ocean. The court rejected the very narrow arguments of the federal government and the Trump administration. They rejected the narrow arguments of the county, and they went with a test, which is now back in the Ninth Circuit. They went with a test that was very close to exactly what the Hawaii Wildlife Fund thought. A big win, and they did it because of the text, not because they're environmentalists, because they're textualists. The decision yesterday, 7-2, disappointing. We thought we had a strong textualist argument in that case, but it wasn't enough for the court. We lost it 7-2. So even Justice Ginsburg wasn't convinced. Even Justice Breyer wasn't convinced of our textual argument. But in obviously the LGBT case decided yesterday, that case was won 6-3. 6-3, based upon the text, where Justice Gorsuch thought there was no wiggle room. He says, I don't care whether I think this is the result that is the right policy result or not. I don't care whether Congress thought about this issue in 1964. All I care what the text says. So if we stick to the text, we can win these cases. And the good news is we got some good textual arguments. There's some good textual arguments in the California waiver case. We got some good textual arguments in the other cases. I'd like to have a new Congress. I'd like to have a new president, but we can get even better text because we're working with really old text. Working with text that Congress passed in 1970, 50 years ago, or 1990 at best, long before we were thinking about climate change. We need new text. We need new leaders. But our text is pretty good. We won't win them all, but we'll win a bunch of them.
Professor Lazarus, is there anything you'd like to share before we wrap up? And just want to thank you again for your steadfast leadership at this really important time. And I think, your comments about fighting for history, that's what this moment is all about. And it really underscores how fortunate we are to have members and supporters at Environmental Defense Fund to enable us all to fight for history, because that is what we are here to do.
Yeah, and that's what I would say. I mean, it's such a pleasure. A lot of people here in attendance to see the Attorney General of California as well. My own relationship with the Environmental Defense Fund started the summer after my first year of law school, when their headquarters was not in New York City. It was on an old farmhouse in East Setauket, Long Island. I was a much younger version of myself with a fabulous full head of shoulder-length hair or so, if I remember correctly. And I worked with them that summer. And EDF is just a fabulous organization. It just combines wonderfully a strong commitment, a passionate commitment to environmentalism with really smart, rigorous science and really smart, rigorous economics. And as the logo says, finding ways that work, being pragmatic, trying to get things done, trying to find common ground where others often don't. And EDF has played an outsized role. Since the early 1970s of the DDT litigation, it's playing an outsized role as well right now in battling the Trump administration. But not alone. There are other organizations too, and the states. The states are playing incredible roles. But that's also what EDF does. It builds coalitions. It builds coalitions to try to make sure we win. At the end of the day, it's not about credit. It's about rulings. It's about changing policy. It's about changing minds. It's not about assuming bad faith. Don't assume bad faith of industry. Don't assume bad faith of elected officials. Try to educate them. Try to work with them. And if it doesn't work, then you bring them to court. And it's been a highly successful organization, one which I've feel just privileged to have been associated with for so many years, and to be able to work with people like you, Vickie, Patton, and to see these extraordinary public servants like the Attorney General of California. So I'm really appreciative of the opportunity to be here today, to talk to everyone on this call, and just by the fact you're here and listening says a lot about your commitment to environmental justice and to the American people and to the world. Thanks very much for joining us.
Thank you, Professor Lazarus. To all who are on the call, if we did not get to your question, or you have a follow-up question that occurs to you after the discussion, please email Kyle Conway at the following email address, events@edf.org, and we'll do our best to respond as swiftly as we can. Our immense and abiding gratitude to the Honorable Xavier Becerra, to Professor Richard Lazarus, and our deep gratitude to each of you for making our work possible. This litigation to protect our nation's life-saving health, climate, and clean air safeguards is crucial. And it comes at a moment of unprecedented threats. I want each of you to know that we will fight for history. We are here and present. We look forward to seeing all of you at the next EDF event. Stay healthy, be well, ganas.
Thanks, Vickie.